and Staff Counsel, Mr. John Wood, for questioning.
Thank you, Mr. Chairman. We're fortunate to have a bipartisan staff. Senior Investigative Counsel John Wood previously served as United States Attorney in Missouri under President George W. Bush. He and I will share today's lines of questioning. Mr. Wood?
Thank you, Mr. Aguilar. Judge Luttig, I had the incredible honor of serving as one of your law clerks. Another person who did was John Eastman. And you have written that Dr. Eastman's theory that the vice president could determine who the next president of the United States is, in your words, incorrect at every turn. Could you please explain briefly your analysis?
It was my honor, Mr. Wood, to have you serve as my law clerk. I could answer that question perfectly if I had at my disposal either Mr. Eastman's tweet or my own analytical tweet of September 21st, but I don't. But that said, let me try to remember the analysis of Mr. Eastman's analysis.
And Judge, I can read to you and to the audience, I think what was a really key passage from your very insightful analysis when you wrote, "I believed that Professor Eastman was incorrect at every turn of the analysis in his January 2nd memorandum, beginning with his claim that there were legitimate competing slates of electors presented from 7 states," and you've already addressed that issue. But your next sentence said, "continuing to his conclusion that the vice president could unilaterally decide not to count the votes from the 7 states from which competing slates were allegedly presented." So what was your basis for concluding that Dr. Eastman was incorrect in his conclusion that the vice president could unilaterally decide not to count the votes from these disputed states?
I understand. As I previously stated in response to Congresswoman Cheney, there was no basis in the Constitution or laws of the United States at all for the theory espoused by Mr. Eastman. At all. None. With all respect to my co-panelist, he said, I believe in partial response to one of the Select Committee's questions, that the single sentence in the 12th Amendment was, he thought, inartfully written. That single sentence is not inartfully written. It was pristine clear that the President of the Senate on January 6th, the incumbent Vice President of the United States, had little substantive constitutional authority, if any, at all. The 12th Amendment, the single sentence that Mr. Jacob refers to, says in substance that following the transmission of the certificates to the Congress of the United States and under the Electoral Count Act of 1887, the Archivist of the United States, that the presiding officer shall open the certificates in the presence of the Congress of the United States in joint session. It then says unmistakably, not even that the Vice President himself shall count the electoral votes. It clearly says merely that the electoral count votes shall then be counted. It was the Electoral Count Act of 1887 that that filled in, if you will, the simple words of the 12th Amendment in order to construct for the country a process for the counting of the sacred process for the counting of the electoral votes from the states, that neither our original Constitution nor even the 12th Amendment had done. The irony, if you will, is that from its founding until 1887, when Congress passed the Electoral Count Act, the nation had been in considerable turmoil during at least 5 of its presidential elections, beginning as soon thereafter from the founding as 1800. So it wasn't for almost 100 years later until the Electoral Count Act was passed. So that's why, in my view, that piece of legislation is not only a work in progress for the country, but at this moment in history, an important work in progress that needs to take place. That was long-winded, I understand.
Well, Judge Luttig, at the risk of oversimplifying for the non-lawyers who are watching, is it fair to say that the 12th Amendment basically says 2 things happen? The Vice President opens the certificates and the electoral votes are counted. Is it that straightforward?
I would not want that to be my testimony before the Congress of the United States. The language of the 12th Amendment is that simple.
Thank you, Judge. Mr. Jacob, I have a question for you. I believe during your deposition before this committee, you said something to the effect of you'd read every word written about the 12th Amendment, the Electoral Count Act, and historical practice. I know in response to the chairman's earlier question, you gave your bottom line conclusion, but can you tell us a little bit about the process that you and your colleagues went through of researching this issue and what conclusion you came to after your thorough research?
So, you, as a lawyer who's analyzing a constitutional provision, you start with the constitutional text, you go to structure, you go to history. So we started with the text. We did not think that the text was quite as unambiguous as Judge Luttig indicated. In part, we had a constitutional crisis in 1876 because in that year, multiple slates of electors were certified by multiple slates. And when it came time to count those votes, the antecedent question of which ones had to be answered. That required the appointment of an independent commission. That commission had to resolve that question, and the purpose of the Electoral Count Act of 1887 had been to resolve those latent ambiguities. Now, I'm in complete agreement with Judge Luttig. It is unambiguous that the vice president does not have the authority to reject electors. There is no suggestion of any kind that it does. There is no mention of rejecting or objecting to electors anywhere in the 12th Amendment. And so the notion that the vice president could do that certainly is not in the text. But the problem that we had and that John Eastman raised in our discussions was we had all seen that in Congress in 2000, in 2004, in 2016, there had been objections raised to various states. And those had even been debated in 2004. And so here you have an amendment that says nothing about objecting or rejecting, and yet we did have some recent practice of that happening within the terms of the Electoral Count Act. So we started with that text, and I recall in my discussion with the vice president, he said, I can't wait to go to heaven and meet the framers and tell them the work that you did in putting together our Constitution is a work of genius. Thank you. It was divinely inspired. There is one sentence that I would like to talk to you a little bit about. So then we went to structure. And again, the vice president's first instinct here is so decisive on this question. There's just no way that the framers of the Constitution, who divided power and authority, who separated it out, who had broken away from George III and declared him to be a tyrant, there was no way that they would have put in the hands of one person the authority to determine who was going to be president of the United States. And then we went to history. We examined every single electoral vote count that had happened in Congress since the beginning of the country. We examined the Electoral Count Act. We examined practice under the Electoral Count Act. And critically, no vice president in 230 years of history had ever claimed to have that kind of authority, hadn't claimed authority to reject electoral votes, had not claimed authority to return electoral votes back to the states. In the entire history of the United States, not once had a joint session ever returned electoral votes back to the states to be counted. And in the crisis of 1876, Justice Bradley of the United States Supreme Court, who supplied the decisive final vote on that commission, had specifically looked at that question and said, first, the vice president clearly doesn't have authority to decide anything, and by the way, also does not have authority to conduct an investigation by sending things back out for a public look at things. So the history was absolutely decisive, and again, part of my discussion with Mr. Eastman was, if you were right, don't you think Al Gore might have liked to have known in 2000 that he had authority to just declare himself president of the United States? Did you think that the Democrat lawyers just didn't think of this very obvious quirk that he could use to do that? And of course, he acknowledged Al Gore did not and should not have had that authority at that point in time. But so text, structure, history, I think what we had was some ambiguous text that common sense and structure would tell you the answer cannot possibly be that the vice president has that authority. As the committee already played the vice president's remarks, there is almost no idea more un-American than the notion that any one person would choose the American president. And then unbroken historical practice for 230 years that the vice president did not have such an authority.
Thank you. I reserve the